Well, good afternoon, everyone. I trust you had a most excellent weekend celebrating a variety of wins. Um, Today, we're going to, I have a makeup lecture for you. It's on liability exposures. We technically started this topic last week with a knowledge Chap, and I was going to record the lecture this weekend. And I thought, hey, we can double down and do this one and begin the homeowners chapter today. That's my goal. And so we'll probably take the full time today. So if you have somewhere else you're planning to be and you have to leave early, I completely understand. So let's start in on this whole idea of liability, because it really is, for most individuals, the biggest risk exposure they face, probably up there with disability, like a lifetime disability or a premature death claim. But a big liability loss can be devastating. It's pretty rare, so it's inexpensive to insure against for most individuals. But when we start talking about commercial liability, that becomes a much bigger issue. So let's talk a little bit about some of these terms that go along with this whole idea of liability. And when we talk about liability, what we're talking about really is your responsibility, or the responsibility of someone, to right a wrong that they are responsible for. And how do you right a wrong in this world? Well, you either owe them money, or maybe a court will ask them to stop doing something. So if you're a company that's polluting, you might be required to pay the damage that you did for the pollution that you dumped. And then it might also ask you to change your behavior. So it's almost always going to involve money, and it sometimes involves an action. But when we talk about remedies that are specific to dollars, there are three different types of financial remedies, or three different categories of remedies. And the first is called special damages. Special damages are economic damages. They have a bill or a dollar sign associated with it that's very specific. It's an expense that was incurred. Versus general damages are non-economic damages for things that are very difficult to put a dollar figure on, like pain and suffering and inconvenience. And occasionally, and that's why there's a dotted line here, there might be punitive damages. Punitive damages are just like they sound. They're intended to punish some behavior that we're trying to discourage. When I was in claims, we would evaluate an accident claim by taking a look first at what the victim's special damages were. So their medical bills, their wage loss, any other specific dollars that they incurred for damage to their injury, their bodily injury. And one rule of thumb, which is absolutely ridiculous, but it was a starting point for negotiations, is that a claim, we used to say it would be worth, you start at 3 times the specials. That just meant if they had $100,000 worth of medical bills and that was their only special damages, we would look at it and say, multiply that times 3 to get a range for what this claim might be worth. So up to $300,000. Now, obviously, those general damages might be different depending upon how much pain or suffering the person endured as a result of that injury. And so special damages aren't always indicative of how big the general damages are for pain and suffering. And it's really interesting that a jury could hear 2 very similar claims, two very similar plaintiffs with similar injuries, and will come up with different damage awards based on how good of a witness the person was. And so that is a huge factor in determining what a claim is going to be worth. It's one of the things that makes claims handling so interesting in my mind. Anyways, so special damage is economic, general damage is non-economic for pain and suffering. And those damages can be massive. And when we talk about the parties involved, The plaintiff is the person who was wronged. They're the one who wants you to pay. They're the person to whom the due was owed. And the defendant is the wrongdoer, or the person who's being accused of doing wrong. Very similar terms that you've heard all the time, usually in relation to criminal law. And every once in a while, you'll have a situation that will be both a criminal law case and there will be a civil law case. The first thing I think of is O.J. Simpson, right? The first case was a criminal law case. And in that one, they couldn't quite get the job done. But the families presented a civil action against O.J., and that was successful. So you can have acts that are considered a criminal act and also have that act cause an injury to an individual that will be the subject of a civil claim. It's interesting when you dig into this chapter. It's not that different from estate planning. And as a student, you might be thinking to yourself, I did not expect to have to know so much law in order to be able to get through these courses. But when you talk about risk management, it really touches, its tentacles are in so many areas, and law is a big one. So we're not going to spend that much time talking about criminal law. I mean, as a risk manager, you might be concerned about criminal law, especially if you are working for a company and you're responsible for overseeing, the risk exposures of a company. And you might be concerned that maybe your employees could be guilty at some point of a crime that they commit, while on the job. And so you might have some concern about criminal law, but most risk managers are going to be more concerned and have much more common exposures to risk through civil causes of action. So when we talk about civil law, there are two giant areas of civil law that involve liability claims: contracts and torts. We just finished up a couple of chapters that really focused on contracts. And so some of this will be fresh in your brain, but generally, in a contract, you have a deal and you each have a role to play in that deal. And you can imagine a contract between maybe you and a plumber, right? Or other business contracts where there is some sort of duty owed to each other, or a warranty that's offered. For example, I think in the book they talked about if you were to sell your car to somebody and say that it's perfect, there's absolutely nothing wrong with it, that you've made a warranty. And that is, if it turns out that the car wasn't perfect, the person could come back and sue you for breach of warranty. And then the area of torts is much broader. It's a private wrong other than contractual. We're defining it by what it isn't, right? It's everything that isn't contract. It's every kind of wrong that isn't a contractual wrong. So torts can be intentional, unintentional, or a strict liability claim. And intentional would include libel, slander, assault, and which could also be, of course, a criminal case. An unintentional tort, and this is big, is really all about negligence or vicarious liability through someone else's negligence. Or, okay, you're a little bit negligent, somebody was more negligent, but both of you are at fault compared to somebody who has no fault. And we'll talk about that joint and several liability. Versus strict liability, which comes into play just for having something so dangerous that it represents such a risk that no matter what happens, you're going to be at fault. I shouldn't say no matter what, but oftentimes you're going to be at fault where strict liability is concerned. So negligence is really the big area that we are interested in. And negligence has 4 elements. The first is that you have a duty to act or not act in some way. When you're driving a car, this is hands down the biggest risk most of us face on a daily basis. Getting behind the wheel of a car and driving. In fact, you should make a habit of it. Unless the person you're with is a terrible driver, but if you're ever given the choice between riding along or being the driver, if the person you're with is a decent driver, just ride, let them drive. It's a good habit to get into because the amount of risk that you are taking on. And if you are ever representing a client who is, has any kind of, recognizability, fame, or celebrity associated with them, the first thing that they should do is stop driving. Because again, this is the biggest risk anybody takes. Anytime I hear of a celebrity that gets in a car accident while they're behind the wheel, I think, what were they thinking? Why would you not have a driver? Because you've just opened yourself up to so much liability. Anyhow, so that the 4 elements starts with a duty to act or not act in some way. The duty to not act in some way would be to don't harass people, don't stalk people. The duty to act would be to, drive with reasonable care. And then the second element is that you've breached that duty somehow. And this is where it's really a little bit dicey. How do we tell if you breached that duty? For example, if the speed limit is 55 miles an hour, but it was just raining, before the accident happened, and you say, look, I was going the speed limit when, I lost control of the vehicle. And your breach of duty might be driving too fast for conditions, even though you were going the speed limit. Perhaps you were going too fast for the conditions at the time. And you're going to rely on a jury potentially to decide what would a reasonable or prudent person have done in that situation. And 3, there was damage or injury to somebody that had that duty owed to them. So if you are a pedestrian and you're in the crosswalk, you feel that you are owed the duty of care from drivers to see that you are in the crosswalk. And if someone breaches that duty by hitting you while you're in the crosswalk and you are hurt, that's the damage or the injury that you would have, that you would present as a claim to the person who had the duty to act. And then 4, there must be a causal connection. There must be a connection between the breach of the duty and the injury that the person endured. And we call this proximate cause an unbroken chain between the behavior and the harm that was done. This can be the source of of maybe a very creative defense. If you were the person that was being accused as the defendant of doing something wrong, one of your defenses might be, hey, yes, they were hurt, but I wasn't the proximate cause. They slipped and fell, before I even approached them because they are just naturally skittish. And I didn't even come close to them. They should have been able to stay on their feet. So you have to be able to prove that there was a causal connection between your breach of duty and the injury that occurred. And so we talk about the defenses to these to negligence claims. And the truth is, every state is different. If you have an accident in Wisconsin versus in Louisiana, where the laws are nuts, you might have a very different outcome, and you'll have different defenses based on state law. But in general, some of the defenses that you might claim if you're the defendant is, 1, the assumption of risk. You're going to say, hey, the plaintiff knew I was a terrible driver. They knew that I had rolled my vehicle 3 times in the last 4 weeks, and they still got in the car with me. They knew it was dangerous. Or the bungee jump, right? You're a bungee jump operator, and someone gets hurt while they're bungee jumping, you're like, look, they knew that this was dangerous. And sometimes that'll work, really depending upon the situation and the jury. Assumption of risk can be effective as a defense. Contributory negligence. This is an unusual defense. In some states, it still exists, but very few. But what it's saying is, if you have an accident, and let's say you were making a left turn. This is you, and this is the plaintiff. You made a left turn in front of the plaintiff, and clearly you failed to yield the right of way. Let's say it's an uncontrolled intersection. And as a result, maybe it was a front bumper to front bumper hit. And your lawyer is going to say, look, Mr. got hurt when I failed to yield to the right of way. You could clearly see me, so you were at least 1% at fault. You should have been able to stop in time. And therefore, because you have any fault at all, even 1% prevents you from receiving any remedy. So that contributory negligence, think of the root of that. If you contributed to your own injury, even a little, you get nothing. Pretty unusual. More likely is you'll deal with comparative negligence laws, where, and there's two different versions, a partial comparative negligence situation or complete comparative negligence. That's very unusual. In Wisconsin, it's a partial comparative negligence state. So let's go back to the situation where we have, let's just start assigning some negligence. And I got to do a better job with this drawing. Hold on. So let's say car Y is the one that fails to yield. Car Z is the car that is upset because you failed to yield and there was an accident. And let's say the person who failed to yield you was, let's say, 85% at fault. You're maybe going the speed limit. And let's say this guy was going over the speed limit a smidge. And so we're going to say, even though you failed to yield and are the majority at fault, let's say that the other car, had they not been speeding, maybe their damages wouldn't have been worse, or maybe it could have been avoided altogether. And so we're going to split the negligence on this 85-15. By the way, this is your whole life as an auto claim rep. You're negotiating on who is more at fault. And so in a partial comparative negligence state, this guy is going to get 85% of his damages paid for. And you aren't going to recover anything except from your own collision coverage if you have it. You're not going to be able to sue car Z for 15% of your damages in a partial comparative negligence situation. But if you're in a state that uses complete comparative negligence, you'll each be able to get from the other. Your recovery is going to be based on the other person's negligence. So in a complete comparative negligence state, you would actually collect 15% of your damages if you were the one that failed to yield, which is silly, in my opinion. So typically, you'll see partial comparative negligence. And this is really boils down to, all sorts of factors go into deciding what are the percentages. For example, what if this car Z wasn't just speeding? What if they're going 120 miles an hour and you had no ability to see them? What if car Z wasn't a car, but was a motorcycle and it was at night and they didn't have their light on and you failed to yield? Then how would you change the negligence split? I don't know, but you probably find yourself less at fault if you were the one that failed to yield. If you can find defenses like that, it will reduce the amount of liability you bear. And keep in mind that we don't need the failure to yield guy to get ticketed in order to present a claim against him. So if we are the ones who are in car Z, we're all going to go get our vaccinations together, and we have an accident with somebody that fails to yield the right of way. I've totally lost my point on that one. Oh, I was going to talk about people being in the car together. If you are a passenger in a vehicle, it doesn't matter who's at fault. You'll be able to collect from anybody who's more at fault than you. So that is, using auto accidents is probably the most example-rich resource we have for illustrating negligence and defenses for it. Another defense would be the last clear chance. So again, going with this failure to yield, maybe car Y started their turn and would have made it through the intersection if they hadn't hit a patch of ice. Completely out of the blue, just a patch of ice. They start sliding, and they start sliding towards car Z. And car Z could have stopped, but they didn't. And so the defense there is maybe car Z had the last clear chance to avoid the accident. All right, one more example, because I don't know the answer to this one, but maybe you do, because this was a real claim that happened. Let's change this up a smidge. Divided highway. And actually it wasn't like it was an area of the highway where I believe, I'll have to double check this. It's possible that the car went through a ditch, but there was a vehicle, 2 lanes in each direction. This is like on I-94. A vehicle heading south and another vehicle heading north. This guy was on his way to practice for a triathlon, about 54 years old. It's like a Sunday morning. And this guy was almost exactly the same age, 54, but he was diabetic, and he didn't take his meds when he was supposed to. And he had kind of a history of not taking his meds when he was supposed to. And he claims he passed out and lost consciousness, and his vehicle crossed the center line and it hit this guy, and this guy died immediately. And this guy wasn't ticketed. In some states, you can be ticketed for failing to manage your blood sugar if you're a diabetic, and that was this guy's situation. So if you have a health issue that causes you to pass out behind the wheel, and then there is an injury that results from that to somebody else, are you at fault for that? What do you think? What does it depend on? What factors would you want to consider? Yep.
Like you said, if this was like an occurrence, like this will frequently happen. When it comes to that guy, you said he's doing this.
Mm-hmm.
Could be like a one-time emergency situation where things are not forced to work out first control. It sounds like in that situation, the person was able and knows that they're doing that.
Mm-hmm.
So that needs to be taken into consideration and thought process behind potentially mitigating their own risks.
So if the person knew that they had a health condition that required attention and then they failed to address that. Yeah. What if it was, I don't know, what if somebody just had an unhealthy lifestyle and just had a massive heart attack while they were behind the wheel? What about that? Would you feel they owed any kind of, would you feel that they could be held negligent for an accident that occurs if they have a medical emergency that they technically were unaware of? You could imagine yourself as a member of a jury hearing a case like this and seeing the plaintiffs or seeing the plaintiff's family members, um, and knowing, if you put yourself in their shoes, you're like, man, that's really, but sometimes accidents happen. It's hard to know who you're going to hold responsible for that, and whether or not a duty was owed and whether that duty was breached. All right, and then last but not least, immunity. I told you about the bike accident with the guy who hit the bicyclist who eventually died, and the fact that one of the issues with that bike accident was that here's the bike path. The bike path had all sorts of shrubs along here and tall grass and trees with big branches, etc. And the driver, as they approached the bike path, even if that bicyclist had stopped, wouldn't have seen the bicyclist. Now the question is, did the bicyclist even stop at all? But this point's moot now, since they've actually come to a decision, and they completely annihilated the driver, who was not even ticketed. You can tell I'm still bitter. But really, is the city at all responsible for not keeping that area trimmed? Technically, I think it would have been the county. I don't remember. But regardless, due to immunity, because as a governmental agency, they're not going to be held responsible for that. Plus, as soon as the accident happened, what did they do? They went in there and they quickly cleaned it up. So, which is good. They should. And there were photos taken to document the way that the scene looked at the time of the accident. But so those are defenses to liability losses or to negligence. And then major sources of liability. I mean, without a doubt, I really like to emphasize, as you've heard me frequently emphasize, automobile liability is your biggest source. But let's walk through the list as it was documented in the book. When you think about property liability, I think about a party in a college rental where you got 30 people on a rickety balcony, right? That's a property liability situation. Or a house with a loose handrail, or a house that is filled to the ceilings with trash. There are lots of different ways that a property can be hazardous. But the level of care the property owner owes to the people who enter is different depending upon whether that guest, quote unquote, is an invitee versus a licensee versus a trespasser. Now, a trespasser, you owe the lowest degree of care to. If somebody breaks, they walk into your house. My neighbor, I am not even kidding, did this. My neighbor walked as we were moving into our house 5 years ago. We weren't quite in yet, but we were doing some remodeling work or having some remodeling work done. And we were in the house at night showing our friends the work that was going to be done. We weren't living there yet. And we heard a noise, and who is on our back porch but my nosy ass neighbor, who was just trying to see what work had been done that day. He would have been a trespasser. So if he would have gotten hurt, technically, the only care I owed him was to try not to hurt him, which is funny when you think about that situation, because I wanted to hurt him. Pardon me, hold on. Anywho, so he's a trespasser. Now, an invitee is somebody I owe the highest degree of care. So if I'm going to have a party and I invite you in, I owe you a safe environment. Versus a licensee, the example in the book is somebody who knocks on your door and asks to use your phone. So they're using your property for their benefit, not for yours. And that's really the definition of a licensee. So the highest degree of care to an invitee, the lowest degree to a trespasser. Now, the whole, whether or not the person falls into each of these categories can really be a matter of reasonableness of the expectation. Is it reasonable for my neighbor to expect to be treated with the degree of care of a licensee or an invitee? Did I invite him in? No. To me, that was a clear case of trespass, but I'm biased. The other way the property can become an area of possible liability exposure is when you are a tenant. So the book refers to the fact that most of us, when we sign a tenant's agreement, that it includes a hold harmless clause, which essentially transfers any premises responsibility from the landlord to you as the tenant. So maybe that rickety balcony might be your responsibility if you're going to hold a party and have 30 people on it. Or as a tenant, if you fall asleep cooking a pork chop at midnight and you burn the building down, you are liable for the damage that you do to the building and to the people in it. So as a tenant, you still have responsibilities to others that are entering the property. Even though you don't own it, you are technically, as you learned in estate planning, you hold either equitable title or you hold legal title. When you're a tenant, you hold equitable title. You have the use of it, and you are responsible for providing a safe place for your guests, depending upon their level of invitee, licensee, or trespasser. Another huge area of liability is with animals. Now, most animals that people own are cute and sweet and don't do that much damage. However, even cute, sweet dogs bite. Huge source of liability claims. And in Wisconsin, if you have a dog that bites more than once, if it's a repeat offender, you can be responsible for triple damages. If you have an animal that's like super obviously dangerous, like a lion, you're going to be held responsible even if someone doesn't, let's say somebody is messing with your animal. It's going to be very difficult for you to get out from underneath any liability if you're taking care of, you own an exotic or dangerous animal. There's another area of legal liability, attractive nuisance. This is typically what you think about is pools and kids. And lots of cases where people have pools and they don't have adequate fencing around it. Child gets in, gets hurt, either falls into the pool or actually goes into the pool on purpose and has an incident, then that could potentially be considered an attractive nuisance. And if you are not providing enough protection against it, you could be held responsible, even if the kid wanders onto your property uninvited. Hazardous waste is another area of legal liability. So if you have especially for commercial situations, but you could potentially see a personal liability situation that might involve hazardous waste, depending upon what kind of crazy hobbies you have at home. All right, then we move on to activities and conduct that are sources of liability. We already talked about automobile liability. And for any of you that are thinking of going into, any kind of career that involves giving financial advice for a fee, errors and emissions coverage is what you'll be purchasing. It's what I pay for. So if I make a mistake when I give somebody advice, I would use my errors and emissions policy to pay for the claim. I had somebody who was upset that they ended up owing capital gains tax when they sold some of their stocks that I had recommended they sell. Even though I documented in the discussion that we talked about the fact that it was going to generate capital gains tax, but it was up to him to sell. I don't have any kind of authority over anybody's assets. I give recommendations. They actually execute the recommendations if they want to. But he was very upset. He didn't realize he was going to have to pay capital gains tax, which I thought was interesting since we not only had talked about it, but it's kind of common knowledge. Anyways, so it didn't end up rising to the level of an errors and omissions claim, but it could have had I not been able to deal with it directly with him. Another area of professional liability can be directors and officers. So if you are acting as a director or an officer for a company, and maybe that company is responsible for some issue that they get sued for, you could potentially be sued as well. There's some coverage occasionally on your homeowner's policy if you act as a board member for a company, but pretty low levels of coverage. Another area of professional liability, which gets all sorts of headlines, medical malpractice. Although oddly, you are held to a higher degree of care when you're driving your car than when you're a physician. When you're driving your car, you're expected to be perfect. Perfect. You should go the speed limit. You should use your blinker. You should go slower if the weather's bad. You should maintain, eyes on the road at all times, etc. Don't fail to yield. Don't follow too close. That's not the case necessarily with physicians. Physicians are supposed to perform up to, a certain level of care, but they don't have to be perfect. And so if you have a bad outcome as a result of an act of a physician, you're probably not going to be successful in suing them. It is very difficult to have a successful outcome when you sue a physician. It's interesting, but it doesn't stop people. And there's lots of medical malpractice claims and lots of people that have money coming. You hear about people that go in to have, something done to their, right side of the body, but accidentally it's done to the left side of their body. So there are legitimate claims. They're just not that common. Not that common that they have a good outcome. There's also operations liability. So if you are on the job and maybe your business is, mostly performed on the job site somewhere, that would be considered. So if, let's say your job is to, maybe you're a concrete company and you're going to go pour a foundation at somebody's house and you accidentally dump concrete all over the neighbor. That would be considered operations liability. And of course, cyber risk, we spent a whole lot of time on last week. If you as a company expose all of your customers' data through a breach, that can be a cyber risk liability claim. And then product liability, huge area of lawsuits. And that can include not just, cases where products ended up being, somehow dangerous because of just they were inherently defective, or maybe there was a breach of warranty. Most products will say use as directed, but if you are hurt, even when you used it as directed, that would be considered a breach of warranty. Or maybe you failed to warn somebody, warning, this Tabasco sauce will hurt you if you get it on your skin or something. Or strict liability, if the product is so dangerous, obviously anybody that gets hurt is going to potentially be able to present a claim, which can be the case, I think, with tobacco, maybe even asbestos, dynamite. Completed operations, this would be, again, defective workmanship, going back to this on the job thing. So if, as a result of the work that was done by your plumber, I actually had this happen not that long ago. It was my plumber's fault though. A water filter for the whole house cracked and was spraying water to the tune of, a gallon a second was coming out of this thing and potentially flooding the house. So if that had been as a result of defective workmanship on the plumber's part. If they had installed it incorrectly, that could be a completed operations claim. It turns out it was really a product claim because the product was defective and they replaced it. Contingent liability is kind of a weird one. Contingent liability is where if you hire a company to do something for you, and they hire a third party to help with either part or all of that job. And if they fail to use due diligence in hiring that independent contractor, they could be held liable as well. Usually when you hire an independent contractor, the independent contractor has their own coverage. But for me, for example, if I am working with a client and I tell the client, look, we need to get a CPA involved to help us figure out your situation. And I offer to hire somebody to do the review. If I don't do my due diligence to make sure that that person is competent, and it turns out there's some kind of crook or just bad at their job. And if I would have done any due diligence, I would have found that out, but maybe I just don't. I forget to, or I think, I know who that person is. I could be held contingently liable for damages as a result. And then liquor liability there's all sorts of laws. If you're going to have any kind of business that's engaged in any way in the sale or delivery of liquor, you can be held responsible for damages that result from even somebody else, driving away from your establishment. If you overserved them, you could be held responsible for any accidents that happen afterwards. So many ways that you can be held responsible and held liable. And liability claims are massive and they're a huge cost. And we take a lot of guff in the US for how sue happy we are. And one of the reasons why we have such a healthy number of lawsuits is this whole contingency fee arrangement. Now, a contingency fee arrangement is where a lawyer says, look, I'll take your case. I don't know that you have a case, but I'll take your case. It sounds good because they don't want to waste their time. And they say, I'll take a third of whatever recovery we get. So let's say you have an accident, you slipped and fell at Walmart, and you're like, I totally want to sue Walmart. I'm hurt. And if that lawyer is having a slow day, or maybe has decided that you'd be amazing as a witness, they'll say, yes, I'll take your case. You don't have to pay me a thing. But once we get some money out of the insurance company, because that's what they're really hoping for, I'm going to take a third of whatever you're awarded. And occasionally they'll say, I'll take a third plus my costs. So if we have to get an independent medical examiner to take a look at you, or if there are other costs associated with trying the case, I want those plus a third. Well, that's kind of like a little Las Vegas inside of a courtroom. That contingency fee doesn't have a cap. And so one idea that continually gets advanced is this idea of capping how much an attorney could collect as a contingency fee. The benefit of having this contingency fee arrangement is that people who don't have a whole lot of money to pay a lawyer would still be able to present a claim under this contingency fee arrangement. And then another idea that gets advanced on how do we limit the number of lawsuits that we have in this country is to shorten the statutes of limitation. So in Wisconsin, I have to fact check me on this. I'm pretty sure you have 3 years from the date of an accident to present or to sue as a result of your injury. So that gives you that 3 years, that clock starts ticking from the date of the accident. And the suggestion is if we were to shorten that statute of limitations that would reduce the number of lawsuits, which may or may not be true. The reason for a statute of limit, why might we have a statute of limitation that's 3 years? What purpose does that serve, do you think? Why would we give you 3 years to present a claim? Or let me rephrase, why would we give you 3 years to file a lawsuit?
If the injury takes a while to fully develop.
Exactly. I mean, that's a great reason. Another might be maybe you're trying to negotiate with the insurance company. You're doing what you can to try to come to a conclusion. One of the things that one caveat to statutes of limitation regarding when you can file, the length of time that you have before you file a suit is if you're a minor, that automatically is extended. So, but shortening the statute of limitation would, in theory, be one way of reducing the number of lawsuits. And then finally, this collateral source rule is sort of funny. You are not allowed to talk about the existing coverage the plaintiff has in court. So if you had $100,000 worth of medical bills and all of them were paid, the jury can't hear about that. They can hear that there are $100,000 worth of medical bills, but you can't tell the jury that those were covered. So there's the chance to receive double the benefit from some of your bills because that collateral source rule exists. So the idea is maybe we get rid of that rule and we're allowed to let juries know that this person was already paid for those injury or for those bills, that would reduce the damages. Anyhow, any questions on liability exposures?